Okay, thank you so much for getting back in and staying until the end. In the interest of time, I think I'm just going to get us started because we have two more presentations, and then maybe we're going to allow for a question and answer session if anybody has questions, and then we will have our closing remarks from Dr. Akeza, and then we'll be done. So, up next, we have Suleiman Shugute, who's going to speak about medico-legal motivation, and I will introduce him before I call upon him for his presentation. So, Suleiman earned a degree of Bachelor of Laws in Hawassa University, and he was awarded LLB degree in Law in 2009. He has attended for his Master of Laws, LLM, in Criminology and International Criminal Law at Amsterdam University School of Law in 2016. And he also attended postgraduate certificate program for judges and prosecutors and awarded postgraduate certificate. And he served as level 1 higher federal public prosecutor on international legal matters from 2009 to 2018 at the Ministry of Justice. He also served as the legal and medico-legal director from 2018 to 2019 at the Ministry of Health, as a medical malpractice and medical legal issues consultant, trainer, and guest lecturer starting from 2013 to date, and legal attorney and consultant of law. Key achievements would be as follows. He has delivered a total of 176 plus rounds of training on medical malpractices and medical legal issues for health professionals working in public and private hospitals, health professionals associations, government-owned universities, and others. He has prepared training materials on 46 topics related to medical legal issues. He has conducted 35 rounds of sponsored training in collaboration with the Ethiopian Medical Association, Ministry of Health, ICAP, and Center for International Reproductive Health. And he has also provided training, so he has received training of the University of Michigan CERT project, and he served as the guest lecturer on medical malpractice and medical legal issues in different medical schools in Ethiopia, including St. Paul Millennium Medical College, Black Lion Hospital, Jimma University, RC University, Gondar University, Hawassa University, and Adama Medical College, and others. Mr. Suleiman delivered various talks and trainings on medical malpractices and medical legal issue matters on different workshops, conferences, and institutions. He drafted preparation on health proclamation, core team, and consultant health professional council proclamation. So with that, I will call upon Suleiman to come forward and proceed with his presentation.
It's really honored to be here. Good afternoon, everyone. This is Suleiman. I'm married, 34. I've got like 4 kids, guys. Say mashallah. I think I'm the only legal professional to be here. I don't know if there is any other one who have been on this stage like me. So it's always an honor to speak before physicians and paramedics whatsoever. Normally, I'm known for delivering legal issues in motivational type. I don't want to like make it a bit serious. Okay, this is my outline of presentation. I do have like, I think 74 PowerPoints, so I'll be expected to cover like 2 PowerPoints every 1 minute. So I'll be very fast, then catch me if you can. I do have some introduction, then I will have some highlights of laws governing the medical profession. I will also have something to say on tests of negligence, then how can we establish negligence in terms of the law? Then why do people sue health professionals? What are the reasons? We do have like some studies that have been conducted on this topic. Normally, to resume, the law do have some level of tolerance to errors. But how is that is actually regulated within the Ethiopia law perspective? I will have some issues to say on that. Then defensive medicine, consent to treatment, and the views of legal standard of care. Okay. You learn legal issues with pictures, of course, and the pictures normally match with contents. I usually use pictures to deliver my presentations because I feel like words make you think, and the pictures can make you feel. I want you to have like, normally as a medical professional, most of you have been customized, to the using of pictures and videos. That's why. So instead of saying a lot about mothers, like it's more enough to adhere to this picture. Let me start with this quote. A law is like a spider web, it catches only the weak. So if you come to a law is not, actually, both of us, like a court, this is normally where I usually be, and a hospital, these are not the best places to be. Like if you show up like in the hospitals, there is a probability that you are not actually taking care of yourself. So we feel like there are mandatory circumstances which might take us to hospitals. But whenever you come to the law, issues are very clear. It's because you are ignorant of the law, or like, if you are good enough to know the law, the probability is that you will not show up in court is like very high. So the weaks only show up in court in me. Okay. This is Dr. Walter Channing. He is a professor of midwifery and medical jurisprudence. He has got a book on a medico-legal treatise of malpractice and medical evidence, which is actually published in 1860. He is of a strong view that, like military officers, to get justice, physicians should be tried by their peers. He is of like a view that health professionals should know enough law. He also have the view that medicine and law may act in a perfect harmony and for equal benefit of both, because courts are mostly influenced by dueling experts. So he strongly advised for the existence of medico-legal professionals to have like subject matter. He is actually strongly advocating for the existence of medico-legal professionals who are actually equipped with the strong knowledge of the subject matters of law and medicine. Okay, caring is normally a state of mind. Unless you achieve it in other parts of your profession, you can hardly achieve it while practicing your profession. Like if you are not caring to your good wife, if you are not caring to your kids, even if you are not like caring to your car, the probability that you'll be caring to the community is very low. So learn to be caring to your life first of all. If you are like strong enough to be caring to your life, then it will be very easy for you to be caring for your patients. Okay, I could have said a lot on this point, but let me go to the next slide. Okay, we do have a problem of getting the balance right. There is a blame culture on the individual who commits medical malpractice. So those medical professionals tend to hide it. They don't want like to come up with, they don't want to disclose it anyway. Even if like when they are like things get known, they tend to justify the errors. There is a litigation problem who do not understand the nature of medicine and how it works. There is an increase in social awareness, which is actually a threat to the health professional. The playing ground is not actually the same, guys. Things are actually changing. The society knows a lot about medicine. In the old times, it's very difficult to have a physician in your neighborhood. By now, like, we do have so many professionals living in and around us. At least on my Facebook page, I can have like 10 or 50 Facebook physician friends. There are colleagues of you who are actually there to give advices on TikTok or whatsoever. So there is a room for consultation. There is a room for second opinion, which means there is a probability in which you can be diagnosed with whatever medical malpractice or error you made. Of course, there is organizational problem which we understand. There are human factors. There are medias actually who capitalizes issues like without knowledge. And we are talking all this having the patient in the middle. So how can we get the balance is always a problem. Normally, a permission to practice a profession does not render lawful actions that might be done within the exercise of that profession. Normally, as a health professional, we don't expect you only to like put attention on the end outcome. We also expect you to put attention on the process. Normally, the law mainly regulated the process in a sense that as long as you adhere to the existing medical standard of care, as long as you make the process good, the law is not interested in the outcome. The outcome could be bad, it could be good, and nobody cares about that. But in case you happen to guarantee the outcome, you will be obliged to deliver it. Normally, a health professional is not expected to guarantee an outcome. But if you happen to guarantee the outcome, then you'll be obliged to deliver it. Like there are actually media promotions running on our the TVs and radios, like like that. Oh, if you say it like that, then you are obliging yourself to deliver that outcome. The law do not expect health professionals to guarantee an outcome because this is a contract of diligence and it's not a contract of performance. Like an engineering contract is a contract of performance, therefore you will be expected to deliver a result. But as a health professional, you are not expected to deliver a result. We expect you to adhere to the good processes, and we expect you to behave in the best interest of the patient. But whenever you give some assurances to the patient that you will be safe, that you will be fine, then we expect you to deliver the same. Okay. So the law normally mainly governs the process, mainly governs. So we expect you to adhere to the rules of standard of care governing that particular treatment or governing that particular procedure. Okay, so the process is equally important as the outcome. So focus on the process, neglect the outcome. The outcomes are not actually under your control. There are various factors affecting the outcome. The probability that you might be having some types of outcome is like, you know the numbers, I don't have to go through. The peculiar aspect of the profession is normally the lack of control element. I cannot control a surgeon who is actually doing a surgery to my wife or to my kid for the very fact that I have some sort of relationship with them. Why the law puts these types of privilege to the health professional? It is all because you can practice with the highest freedom. It's not any other thing. But you guys, you are actually abusing that state of lack of control element to the negative interest of the patient. We don't expect you to abuse the lack of control element. I can hire a physician or a gynae professional or a surgeon to look after you. That is a control element. But the law intentionally disregards that types of alternatives to patients or to the families of the patient to let physician practice with the highest freedom. And there is no time for discussion over there, actually. So we expect you to, we don't expect you to abuse that privilege that have been given to you. So there are various laws governing the health profession. There are ethical guidelines, criminal laws, civil laws, administrative laws, proclamations, regulations, directives, and normally international documents to which Ethiopia have been a signatory. It's deemed to be normally any laws that have been signed by Ethiopia at the international level is considered to be part of the law of the land. So, like Lisbon Declaration, like any patient right proclamations which have been issued at the international level are also normally parts of the law of the land. So the laws are actually enacted on the basis of accepted standard of care in the medical community. So the big misconception about medical-legal issues is that this field is not regulated. Of course, there is a question up to sufficiency of laws in the area, but there are actually active laws working in the country. Types of rules governing medical law. Two types: preventive rules and disciplinary rules. Disciplinary rules, they are intended at punishing those professionals who give substandard care to the patient. Preventive rules are normally intended at protecting the safety of the patient. Most of the laws in our country are actually disciplinary rules, but disciplinary rules alone, they cannot promote patient safety. You should have more of preventive rules and a little bit of disciplinary rules because that will enhance the patient safety. There is a transition area in terms of liability, like at the international level or mostly in western part of the, in the West. Learning model is the prevailing type in addressing issues that has got to do with medical-legal issues or medical error. When you adhere to learning model, it means you are not actually focusing on the professional, but you are actually focusing on further like on what should be done to prevent further accidents. You will try to learn from the error it means. When it is a punishment model, you actually focus on punishing the center or the individual who is actually involved in doing that particular malpractice. So the punishment model is actually outdated, so we should learn from our mistakes, because medicine by itself reached this stage like by learning from its own mistakes. So punishment model is no more there to address issues that has got to do with medical error. So we should we should like do more to learn from our errors. This is not actually working in our context. We are still focusing on the punishment model, which actually I'm against. What are the elements of medical negligence? Normally, it is a professional negligence in a sense that to regard an act as a medical negligence, first of all, you should be a professional in that particular field. So if you are actually working out of your scope of practice, it will not be a professional negligence for you. It will be considered like as some other acts of ordinary layman's behavior. So if you are like an ophthalmologist and you are actually found like incurring appendix, so we don't treat you as a professional in that sense. We consider your surgery as act of stabbing. Like it's no more different than that. Good. And it might be an act or it might be an omission. And the treatment actually falls below the standard. And there must be an injury or days to the patient. Of course, intention is always excluded when it comes to the medico-legal issues. So the test of negligence is, on this side, you will list down like how the health professional ought to behave. Then on the other side, you will list down like what the health professional actually practiced. So if you find like there's a significant difference between how the health professional ought to behave and how he actually practiced, have in mind this a significant difference. Like minor differences will not result in negligence. To regard an act as a medical negligence, there must be a significant difference between how he ought to have behaved and how he actually practiced. So a professional might be liable for negligence as one of the two findings. First, for he has not possessed of the requisite skill which he professed to have possessed, or for he did not exercise with reasonable competence in the given case the skill which he did possess. Okay, these are actually some international cases that has got to do with negligence. Probably you might know them, I believe. The first one is Dr. Conan Murray. This is a personal physician of the singer Michael Jackson. Michael Jackson is actually insomniac and is not able to sleep. He has got a concert in London, so he went to some rest, so he's asking like for some psychotropic drugs. So his physician have been giving him some petadine, diazepam, blah, blah, whatsoever. You know the details. And he's not responding to that, so he asked like for more, like give me more like some strong medicine. So his physician decided to give him propofol. Normally that propofol come up with a cardiac arrest, and days happened. Normally this physician has violated 60 rules of adhering to administering propofol, one of which is actually he cannot give this particular drug without the hospital setting. The administration should be within the hospital setup. Dr. Cecil Jacobson, this is a fertility doctor in US. He used to do artificial insemination for those like families or couples unable to give birth through the natural birth mechanism. So this man is big crazy. Normally, what I'm saying is like his acts. You know what he used to do? He will take samples from the couples, and once they leave, he used to substitute the samples of the husband with his own samples. So at the time of his conviction in US, he is a biological father to 72 kids. Okay, Dr. Joseph Mengele, hopefully you know this physician. This is a microbiologist, and he used to do all those nasty experiments on Jewish that have been in Auschwitz camp, blah, blah. Okay, then why do people sue? We have interviewed like 128 victims of medical malpractice in Ethiopia, and they said this. We asked them, why did you sue the health professionals or the health institutions? They said, guys, 52% of the respondents said, oh, we were advised to sue by the knowledgeable accusers, they said. We were advised to sue by the profession themselves, they said. ራሳቸው ባለሙያዎቹ ናቸው ገፋፉናሉ። እኔ አይዶን አንዱ ለሰው ነው እዚህ ጋር አማርኛ ችግር ያለበት ሰው ያለው። ግን እቺኛውን ነገር በደንብ መነጋገር ስላለብን ነው። ለምንድን ነው ከሰሳቱ ስንላቸው? they said, we were advised. Like what sort of advice? Oh, especially majority of the cases normally happen during the referral. So you do have the chance to speak something about whatever has happened at the at the former treatment. So እንደዚህ ያደርጉሻው እንደዚህ እኮ ማድረግ አልነበረ ቆይተሻል እኮ ላይክ ሞተሻል እኮ ይሄ እኮ ላንቺ አይገባም ነበር ይሄ ላንተ አይገባም ነበር እኮ እሱ እኮ የቢ ተማሪ ነው የዲ ተማሪ ነው የሲ ተማሪ ነው. Those are actually issues triggering medico-legal ማለት ነው. 52% of the case is actually attributable to the behaviors of you guys in your like premise whatsoever. So we expect you like to behave prudently over there. I do understand the patient is right to know everything, whatever has happened to his body, but that should not compromise the interest of other health professionals as well. Then some of the interviewees said they do not listen to us. So the others said professionals did not talk openly. Some of them, they needed the money. Of course, some of them, they recognize they cover up. Others do have the issue of trust. We do have the issue of trust with you guys. Others normally do have the misconception of how the health system actually works. Okay. Then the same people which we have actually interviewed, like in cases with a moderate or little outcome, if the institution or the physician is actually honest, empathic, and accountable, there is no strong advocacy for going to the courts or. But the problem is, you guys, you do have a problem of saying sorry. Sorry, ማለት ችግር አለባችሁ. Like within the law, the mere fact that you have said sorry to the patient doesn't mean like you are liable for a particular type of like problem or accusation. But you should learn to say sorry because that will avoid medical legal issues. And I do have my own medical legal consultancy office, and I do have like 100 plus health professionals who are actually my client, including full professors, assistant professors, physicians, like GPs, nurses, paramedicals. All of them, do you know what they have in common? They don't like to say sorry. That's what they do have in common. I want you to say sorry to one another. Yes. Say sorry to one another. You should learn to say sorry because it saves. It actually saves. Okay. Let me jump this global perspective because I'm running out of time. Okay. One of the fundamental reasons why health professionals and institutions get sued is it is because of poor documentation. So, document it. Whatever is not written on that particular chart, it is considered as if it is not delivered to the patient. So, whatever referrals you made all the night, whatever the hysterectomies you did, the blah blah, the units of blood you give, the oxytocin you message, whatsoever, if it's not there written on the document, then the consideration is that it's not given. So, have in mind the timely recording of the timely documentation as well, because once the law officers or the law professionals show up there, it will be too late for you to document. And there are actually various charters which are actually incomplete normally in the ethics committee in the courts. Okay, then what are the top 10 reasons why health professionals or institutions get sued? First, documentation. Second, inaccessibility. Third, follow-up, informed consent, rudeness, tracking, communication, and non-compliance within the Ethiopian setup. Actually, okay, this is actually a video. Let me jump some. Never assume, always ask. Most of health professionals tend to assume facts, but in terms of the law, that might not exonerate any types of liabilities that might come to you. So do not adhere, like do not tend to assume, but always ask facts from the patient, ask facts from his family, ask facts from your colleagues and whatsoever. Any life that you take is not just one life, it is all that is connected to the life. So fundamental cause of medical error, human error, there is system error, there is a contribution by the patient, there is organizational error. But within the Ethiopian setup, like most of the liabilities it is focused on the professionals. So the professional has to carry all the burdens that has got to do with the system error, with the organizational error, and with even contributions with the patient. It is just like, guys, what you used to say, all the critics goes to the printer, no? Oh, so all the medical liabilities, all the medical error blames goes to the professional. So whatever has got to do with the system, organizational error, it means actually this is an act of contributing medical error by non-medical professionals working within a hospital setup. Okay. So we need to develop a system view, which means which actually focuses on the input, process, and outcome as well. Actually, these two bases, two trains, they have Tagashtal, and this is one of the worst accidents in India. I think this is not the duty of the captain to forecast this damage. That is normally the duty of the system. So there is this much difference between human error and the system error. But within our context, it is the physician whom we are actually holding liable. Okay. So disclosure of medical receipt promoted. So justifying a double seat. Of course, tourism. There are actually countries who promote tourism. In our context, የመዳን ቀን ዛሬ ነው እየተባለ ነው ስብከት እንደ ስብከት እኮ ነው የሚመስለው ባይዘው የህክምና ተቋሞቻችን ማስታወቂያ ዋስትና መስጠት የሚመስል ነገር በሙሉ አስወግዱ በህክምና ውስጥ ኑ ትድናላችሁ አይነት ነገር አትበሉ ፕሊዝ ስብከት አይደለም የተያያዝ ነው ህክምና ውጤቱ ምን እንደሆነ አይታወቅም ሶ ወደዛ ኢንክላይን ያደረገ ነገር ራሱ አታው ኢንክላይን because in the long run the patient tend to expect something from that particular treatment. So, okay, perfectionism is normally a common trait among health professionals, we understand. So but it's important to remember that health professionals are human too, so they will make mistakes. So, the law actually focuses on grave professional faults only. Minor negligences are not included. Minor negligences are not included. So there is some sorts of tolerance to error, it means. But never this much. Okay. Guys, some of our bodies actually look like the plants or whatsoever. You can see a walnut, it looks like a brain. I don't want to keep things serious, so you want to smile demo kananta lamagit chinamata. Okay. A walnut, it looks like a little brain. You can see left or right hemisphere yallo yimeslal cerebellum namin allo. Oh. So all of the studies shows walnuts are actually important to our brain. Okay. Sweet potatoes, it looks like a pancreas. So all of the services goes to the service of pancreas. Avocados, it takes normally 9 months for an avocado to fully develop. As well for the mother, 9 months. Okay, it looks like the ፍሬውንስ አነው ካላችሁት ፍሪ ባዶ ቦታው ደግሞ እንደ ማህፀል ተስዱ ትችላላችሁ. It looks like shape ራሱ it looks like the mother's womb. So one avocado for one mother. There is an advocacy of like that in WHO as well, because any mother normally who eats one avocado every day, she can the cervical cancer post or whatsoever pregnancy complications like ይጣቅማታ ይላል. Okay, tomatoes has got 4 chambers, the heart has got 4 chambers, the tomato is red, heart is red, blah blah. Okay, carrot, it has got 3 layers, so it's important to the eyes. It goes on like that. Okay. አለፍኩት በዚሁ defensive medicine this is actually adopting practices which are not medically required or justified, so adopting a procedure which are not for the benefit of the patient but to safeguard against the possibility for negligence. So you are here to protect your own interest, not to protect the interest of the patient. So defensive medicines could be positive defensive medicine. Normally this is undertaking additional procedures which are in the judgment unnecessary for the interest of the patient. These are actually wasteful of time and the resources, and it increases the risk to the patient of medical interventions. Okay, negative defensive medicine is avoiding procedures which are in the professional judgment are necessary in the patient's best interest, but because of something going wrong, you will avoid it. Okay, so this will deprive the patient's potential beneficial treatments. Okay, consent to treatment, I have to pass these concepts for probably you might have better awareness. Okay, I want to go to the standard of care. Good. This is where I should have my time. Normally, the legal view of standard of care. So whether the health professional has failed to meet the standard is always an issue. So the test is normally a test of reasonable man standard. So when does the duty of start? When the duty of care stands, normally there is no fixed point, but most literatures normally agrees on registration. When the patient is registered, the standard of care normally starts. Then how do we measure the adequacy of standard of care given to a patient? to come up with any types of liabilities, we need to measure the standard of care that is given to the patient. So it must be measured relative to the availability of resources, knowledge, experience, situation, complexity, probability of cure or whatsoever service, or subjective circumstances, and the workloads on the table. Okay, medical standard of care and legal standard of care. Normally, the legal standard of care, it refers to the amount of skill that a medical practitioner should exercise in a particular circumstance. So it provides the minimum quality of medical service that a medical professional delivers to the patient. So that's normally actually based on reasonable and a common professional practice. So the focus of legal standard of care is normally what you can do to your ability. Okay. So there are different types of standard of care: internal standard of care, external standard of care, national standard of care, local standard of care, emergency. I would be pleased to explain all those, but I do feel like I do have lack of time. So what is the scope of duty of care? Accurate assessment diagnosis will be measured when it comes to the courts. It means timely and appropriate investigation manoru, safe and effective treatment manoru, giving information on disease and medication, obtaining consent, appropriate timely referral, responses when called to attend. All those will be considered when it comes to the law. Okay. Okay. I want you to focus in here. No health, the law actually prescribes, no health professional may prescribe medicine formulation about which he has no knowledge about its composition or pharmacological actions. So the belief is that you know the drug you are actually using or prescribing to the patient. Second, there is an obligation to serve despite belief, and you cannot use your own personal beliefs to deliver something to a particular service to the patient. Okay. There is also an obligation to prescribe medicine registered in the national drug list only, but you should bear in mind no health professional may undertake medical examinations for himself. Okay. There is a duty to discharge your service in teamwork in light of the law. So it's no more like an ethical liability, it's a legal liability to work in a teamwork. Okay. Leicester City is a good example to promote teamwork. Even if you find a mistake, then we expect you to rectify it. We don't want you to capitalize those issues. Always poor teamwork has got its own medical legal liabilities. You should treat both the disease and the mind. It's the current framework for treating the patients. You cannot only focus on the disease. You should also do your best to treat the mind as well, because the patients always will be there to look for second opinion whenever they are not convinced. Okay, so do what is right, not what is easy. So in light of the law, if you do what is easy, you are always under liability. So we expect you to do what is right, not what is easy. As a professional, you cannot say, I am responsible for what I said and I'm not responsible for what you understand. As a professional, you are responsible for both what you say and what the patient understands. So you are always under duty to make sure the patient understands your communication. Sometimes the importance of adhering to those instructions as well. So you might be speaking something so sound like this, but the patient might, so you are always under duty to make sure, okay, passport size passport size photographs, okay, good. Expand the following equation. He goes on expanding the bracket, so that is how he understands it. So if this is a health professional, then we would hold him liable. Oh, he's actually saying the health professional has prohibited me from drinking, like, what? You can see that, okay. So neglect of duty does not cease by repetition of neglect of duty, which means wrong is wrong, even if everyone is doing it. Right is right, even if you are only doing it. So the mere fact that you are actually doing things in group will not exonerate any types of liabilities that might come to you. Okay, it's better to walk alone than working with a crowd going in the wrong direction. Okay. Oh, do not say this is not my job አትበሉ እንደ ጤና ባለሙያ የዚህ ሰው የሥራ ቀለም ማስመር ነበረ እንጨቱን ማንሳት የኔ ሥራ አይደለም ብሎ ነው እንደዚህ ያጣሙ ያሰመረው እሺ okay let me read this one and I will stop it. Okay, read every document until the end. It says hello Dad Ilan, I did not tell mommy that you kissed her friend Noran at the birthday party. I did not even tell her that you slept with her in your bed. Anyway, you should be thankful to mommy because she helped me to write this letter. It says you guys, especially during reference, they might be like 2-3 pages a dose of issues written over there, you might feel like, I have already known your problem. Like you don't obligate yourself to read the whole of the documents. You feel like you understand it, but you missed it sometimes. Okay, so scope of practice. Not every place you fit in is where you belong. So you should be aware of your scope of practice. ዝምብላችሁ አትዘርጉ እጃችሁ። እሺ you should normally update yourself on the existing medico-legal or even on the active sciences that is actually working. Guys, if I ask you this question, like, who is the all-time NBA scorer ብዬ ብጠይቃችሁ probably ብዙዎቻችሁ የምትሉት ማይክል ጆርዳን ነው። ብዙዎቻችሁ የምትሉት ግን this fact has already changed. ይሄ በ2006 ምናምን የነበረ ፋክት ነው። አሁን ላይ ከሪም አብዱል ጀባር ነው። what I mean to say by this is የሆነ outdated በሆነ እውቀት የምታክሙ ሰዎች አላችሁ። the science is changing. አንተ የሆነ 86 ላይ ነው ያለው 96 ላይ ስታክ አድርገህ ቆመሃል 2018 ላይ 22 ላይ ደግሞ ሌላ ህክምና ነው ያለው so the law always puts an obligation on the part of the health professional to update himself continuously so it's not a difference that the science has changed it mean in light of the law እሺ የባህል ህክምናዎችን ማን ነው የሚያናግራቸው እንግዲህ ፈጣሪ ወቀው ለትምህርቱ ላኮ እንትን አላቸው ህክምና አላቸው ለጨብጥ ምናምን ለትምህርት ለስፈቶ ሲብለው ለጆሮ ለአስተሳሰብ ችግር ሁላ I don't know you can see these are some of his tight pambo splits ምናምን ብዙ ሰዎች እንደዚህ አይነት የሚመጡ አሉ ህግ ቦታ ላይ ስለዚህ we should balance ዝም ብለን ኮንቬንሽናል ሜዲሲንን እየጠየቅን ትራዲሽናል ሜዲሲኖችን ደግሞ ዲስሪጋርድ ያደረገ ስርዓት ነው ያለን ግማሹ ማህበረሰብ እኮ ትራዲሽናል ማህበረሰብ ጋር እየሄደ ነው በተለይ ገጠር አካባቢ ላይ ለብዙ ነገሮች so you subscribe to change you won't prescribe it respect, teamwork, communicate, trust, and listen to the patient as well. I do feel like I do take some time. This is a bit different topic. So, እንደናንተ scientific ምናምን ነገሮች 30-20 ደቂቃ ለሜዲኮ-ሌጋል አይበቃም. Normally, my rule is always to have like 1 hour. So, they gave me 30 minutes. እኔ ደግሞ አንድ 15-10 ደቂቃ ሰርቄያለሁ. So, guys, you will forgive me for that. Thank you very much.
Gentlemen, what a refreshing presentation, huh? Let's give him a round of applause. One more time, please. Thank you, Suleiman. Jack is my kind of son, you know, but Daddy, you must thank Mom because she helped me write this letter. I love him. He's a genius. Yes, and keep out of reach of medicine, blah, blah, you say, doctors. Now he says, keep out of the courtroom. Don't get in a mess. I know. Very interesting. I trust you will be able to share your presentation with a lot of us. So much to learn out there. Okay, great. Finally, we have Professor Mengistu Kifle. Professor Mengistu is going to talk to us about telemedicine. In terms of the